Yes. Unaona sasa mmefunguka because mnaona nakuja kwenu. Mimi ni mwalimu.
Praise God. As a young person, I'd like to know if I can have a will or if I can write as a young person.
Thank you. You see, those are valid questions. Any other volunteer before I come to you?
Me also.
Hata wewe.
Hi, my name is Maxwell again. I'd also like to know why would a youth care about issues to do with estate planning or writing a will?
Thank you. My youth hawakuangi na megoda. The last two. Any person? Patia yule.
I want to know the importance of inheritance or making a will.
Tell us your name. Hatuski. Your name.
Charity.
Charity. This gentleman over here.
Good afternoon, all. I'm Jeremiah. I actually came here to learn more about matters of inheritance and most likely how to leave behind a valid will and reasons of how a valid will can be invalidated by maybe a court of law. Thank you.
Thank you. I think that is enough for now. Now we know what your expectations are. We'll try to confine ourselves within those expectations so that at least you can learn. When we talk about estate planning, there are many things we refer to. Sorry, I need to introduce my panel. I think I'm being very fast. I'll start with Jonathan Mwangi. Just say hi to people. The mic.
Hello. Okay, fair enough. I'm Jonathan Mwangi, an advocate of the High Court. I think that's it.
Jonathan has practiced for more than 7 years. Thank you, Jonathan. Yes. Then I have Kariobangi.
Good afternoon, everyone. Yes, that's my name. I can confirm that I am Ishmael Kirago, and I'm pleased to be here. I'm hoping that we'll meet your expectations and we'll interact further. Yes.
Kirago has practiced for more than 9 years. He's currently practicing at the DPP's office, Director of Public Prosecutions. Ukishikwa tu unaweza mpigia simu, utafunguliwa just that minute. Ukisema tu unajua Kirago Maige, sidio Kirago? Then I have Kaka Kamau.
Good afternoon, everybody. My name is Kaka Kamau. I am an advocate of the High Court of Kenya, and I'll be taking you through on the issues of what constitutes a valid will in Kenya, the characteristics of a will, and what is expected of you as and when I'm called upon at the chair there. Thank you.
Kaka has practiced law for over 19 years. And my name is Susan Dirango. I have practiced law for over 25 years. And we are grateful to God. So when we talk about estate planning, when you die, we do not refer to your properties as your properties. We now stop referring to you as a person, and we call your properties, everything that belonged to you, an estate. Tuko pamoja? So when we are talking about estate planning, it is planning after death. Remember, we all have to die, isn't it? When we are talking about heaven, the bridge to heaven is what? Is death. So we should not fear death. And we should not say that we are not going to talk about estate planning because we are going to die tomorrow. The fact that you plan your estate doesn't mean that you're dying tomorrow or today. What you do when you plan your estate is that you ensure the loved ones, the people you love most, will not fight. They will have a smooth transition in order for them to access your property. So today, we want to focus on a few things. We do not want to focus on the entire inheritance process because we are here to tell you that it is important as a Christian, as a man and woman of God, it is important to be orderly. So we shall be talking about planning. Now, and I want to ask, is estate planning biblical? Is it biblical? Yes, it is biblical. God carefully planned our inheritance in heaven. If you look at the journey from Abraham to Moses, the way the Israelites left Egypt to the wilderness, all the way to the promised land, then they used to sacrifice so that they can make right with God. God realized that that was not enough. So what did he do? He gave us his only son who came to sacrifice himself so that we can inherit the kingdom of God. Isn't that a plan of God? So that man will not get lost. And that was the planning of God to inheritance. So even as we talk about inheritance here on earth, let us not lose focus about our inheritance in heaven. We have a few Bible verses, and I don't want to read all of them. If you go to Ephesians 1:11 to 14, it talks about the mark of a believer. You believe in God by confessing that Lord Jesus is Savior. And then if you look at the book of Genesis, the story of Abraham, God blessed him with a son so that he could get an inheritor or a successor. Then we have Hannah, who also prayed to God, and she was given a son. The book of Job, 42 verse 15, and I want to read it. It's a very interesting verse. And it says, nowhere in all the land where there found beautiful women as beautiful as Job's daughters, and their father granted them an inheritance along with their brothers. I want you to keep that verse in mind as we discuss about writing a will, about inheritance, because I know that question will come up. Job granted them an inheritance along with their brothers. So I want us to think about that as we progress. The reason why we talk about estate planning and the reason why we encourage estate planning is because, like I said before, we are not here forever. One day we shall die. And therefore we need to live an orderly, we need to be orderly even after death. Number two, we serve a God of order. Our God is a very orderly God. And then we are Presbyterians. We are guided and governed by the practice and procedure. It is a church of order, mutaratara. So as Christians who belong to this church, we are also called to emulate our God who is orderly. We are also called to emulate our church and become orderly people. It's actually very embarrassing when a Christian dies and we find ourselves in court fighting. We find ourselves in court because people did not make disclosures. People did not say, I had 3 children outside marriage. So during the funeral is when we see people coming, claiming that this is my father. Men, please allow me to say that. This is my father. And the wife and the children didn't know about it. But if you had planned your estate properly, you'd have included those people because they are your children. And the law recognizes all the children, whether they are born in or outside marriage. And then if you look at the story of creation, God had a plan from the first day to the seventh day. He had planned, today I'm creating this, today I'm doing this, the seventh day he rested. We are supposed to emulate God and become ordinary people. We are in a country which has rules and laws, and we have a constitution. We have many other laws that govern us. We have the traffic laws that tell us you cannot do this speed, you can't drive this way, you can't do this. Why? Because we are supposed to be an orderly community, an orderly country. Because a country that does not have order, it has anarchy. And what is the importance of estate planning? One, it enhances unity, love, peace in our families, and it also brings cohesion. When you plan, your family will live in peace. Number two, it reduces conflict within the family and also court battles. Number three, it reduces legal expenses and other related expenses. You've heard what, I can't remember this, from KCC, the gentleman from KCC, I can't remember his name, but what he has said is that you'd like to learn how to write or to take a petition or to draft a petition so that he doesn't have to use money in legal matters. However, we are your children, we are your sisters, so if all of you decided to represent yourself, you are telling us to get out of. Yes. So think about it. It could be your daughter, it could be your son, and it may have implications. But the reason why we are saying it reduces legal expenses, if you come to me with a planned estate, it is different from an estate that is not planned. Because even the number of court attendances is different. The number of the papers that I'm going to do, they're different, they're minimal, as opposed to an estate that is not planned. Then the other thing is that there is fast tracking of the administration process. An administration process where there are no issues, there are no objections, is supposed to take 1 year. However, where we have objections, you can take like 10 years. I have a case which was filed in the year 2006. We are still in court. We have only been able to distribute one property, and they are children from one mother, not from two mothers. 5 of them so far have died. They have not enjoyed. Do you see the expenses? So at the end of the day, you'll fight and you'll not get what you are fighting for. Now, quickly, we have many types of estate planning. The first one is joint ownership. Joint ownership is where you register a property together with another person. This is mostly recommended if you want to register a property jointly with your spouse or with your son or daughter. Why? Because unless you go to a lawyer who is very familiar with conveyancing or a lawyer who is familiar with succession matters, they may tell you to register something jointly without telling you the repercussions. So joint ownership recommended for couples or yourself and your children. Because if you register it with your brother, with your mother, when you die, that property automatically refers to the surviving owner. Are we together up to there? The other one is insurance matters. When you take out an insurance cover, when you take out an insurance cover, please ensure that you keep updating it. If you take it when you're single, when you get married or when you marry, update that. When you get children, update that and give percentages. Circle matters are giving us problems. People join circles when they are still single, they do not update the information. When a husband dies, we go to the circle and we find the person who is the next of kin is their mother or father. Unfortunately, that person has also died. Where does that leave us? That money may go to your brothers or your sisters because they will say, this was our mother, this was our father. So update your records. Update your records. As you age, as you take out policies, as you take out even circle matters, anything where you are asked about your next of kin, please make sure that you update. The other one is what we call, you can give your beneficiaries or your people what we call in law gift inter vivos. Don't think about that. Just think about a gift. You want to give your child a gift. What do? You can register that gift in his name and your name, or you can register it in his name alone. However, when you die and you have no will, that property will also be taken into consideration by the court. But it is better because you empower them. For example, if it's a couple and you give your wife or your husband, if you have rental houses, just for example, and you register that property in joint names, if that is the only income that you have, if one of you dies, the other one will not suffer because automatically it reverts to you. So life continues. Then we also have something we call a trust. That one is for another day, but you can create a trust where you can say, like Elder Kangeve here can create a trust and say, for all my properties, it will not go to any individual, but it will be consolidated. I have appointed so-and-so to be a trustee, and that money will educate my family lineage. The grandchildren, the great-grandchildren, so they are educated. You can do that. And that will sort out most of the problems. And then what we want to focus on today is the drafting of a will. We said we are orderly, isn't it? So today we want to focus on drafting of a will, and then I'll call Kaka Kamau so that he can take us through. And as he comes, I told you he's an advocate of 19 years and above. He's a family lawyer, very knowledgeable, and I believe that we'll be blessed.
Good afternoon, all, once again. I'll be taking you through on the issues of the drafting of a will, which is a very important topic in my view. But firstly, before we look at the essentials and what it entails to write a will, I need to bring it to your attention that the most basic step in estate planning involves writing of a will. A very, very important concept. You have to write your will as part of your planning. Why do you think it is important to write a will? One of the importances is that all of us have different intentions in life. And I want to give you an example before I go to what constitutes a valid will with an example that I'm just handled just the other day. I have a client who has a home somewhere in Tigoni. He has other properties and he has 5 children. But one of the daughters stays with him in their Tigoni home, and she has 3 children. Now, those children have grown up in that estate, while the other sisters and brothers, some of them are staying on their own. And when we were going through his issues, he actually told me once that, these grandchildren of mine have never known any other place as their home apart from this home. So that if I were to die today, I would want my daughter to inherit this house. She is not the last born, but because she has children, she's single. All her children have grown up in that home. That was his wish. And he was asking me how we can go about it. And I told him one of the things that you can do is to write a will. Now, the importance of a will is that you distribute your properties according to your wishes, not according to any other person. It is your wishes that count, so that you know your children, you know their strengths, and you know which child needs what. So you are able to plan. Now, failure to do that, you will now leave this issue to a court. Now, a court will be a judge who does not know you, does not understand your family values, does not understand your children, but then your property is going to be distributed how the court deems fit. So that it would have been your wish that perhaps this particular child gets this property and this one gets this property. But because now we are dealing with a court that does not know them, the court will just distribute the property equally without taking into considerations the strengths of these children. So that is one of the most basic intentions of why it is important to write a will, because it allows you to distribute that property the way you want, not the way a court would want or another person would want. Because believe you me, you could have a very good family and they are all together. But what most of us fail to understand is that you could be the reason this family is united. You are there. They are all united. They are all one. But unknown to us sometimes, you as parents are the only reason these children stay together. So that the day you move out, the day you pass on, division start. And the same family that was once so well united, loved each other, they all become completely different because you are the unifying factor. So why once again would you want somebody else to determine who goes with what? And it is your hard-earned property. You got these children on your own. It is your intention that this property of yours should be distributed the only way you want, but not the way any other person would want. So having said that as my introduction, I want now to go straight to what constitutes a valid will in Kenya. The first thing that needs to be done is that the person who writes a will in law is called a testator. A testator is the person who writes the will. So if you write a will, we term you in law as a testator. So the first thing that you need to do, you must be of sound mind at all times when you are writing your will. That is the first consideration that we take upon, because you know with time, people have different infirmities. You could be unwell during that period. So the first characteristic we look is that you must be of sound mind when you're making that will. You could make a will today, then you get dementia, like we all know these things happen. But your will will be valid because as at the time that will was written, you are of sound mind. The second one answers what my young friend there asked. You must have attained the age of 18. So yes, it's true, you too can write a will. Age is nothing as long as you are 18 and above. So that is one of the issues there. So the other thing is that since it is a document, you must then sign that document, the will that is going to be written. It must bear your own signature. It must bear your own signature. The other thing that we find is that we need a minimum of 2 witnesses. There has to be 2 people who are witnesses, and preferably people who have no interest in your estate. You will not put in your son as a witness, and perhaps he's the one getting the lion's share. Perhaps later in life, issues could arise. So it is always advisable that you must, at all times, have 2 witnesses. Then, another issue that will be important is, can we have a will that is oral? Can you just declare, I say, my son, you'll get that, my son B will get that, this will get that. Can you have an oral will? Interestingly, yes, you can have. The unfortunate thing is that then you must die within 3 months. What that means is that it is only valid for 3 months. If I make an oral will, it is only valid for 3 months. And mostly it's happens like people who are in the military, people who are in a state of war. So when they are going, they can decide, or people who are sailing on a ship, they say, I have decided that my property will go, particularly because some of these things, we inherited some of these laws, and the British people who inherited these laws, mostly because they were sailors. Sometimes people will be called upon to declare how they want their will to be, how they want to write their will, and they'll give an oral will. But after 3 months, then that will is no longer valid. Then another thing is that you could write your will today. As at the time you wrote your will, you only had 2 plots somewhere, but later on, you could acquire more plots, more properties. So somebody might ask then what happens? You can actually write or add an addition to that will. In law, the word we use is a codicil. You have an additional will so that you now are able now to include that other property that you hadn't included. You might also have a situation whereby you now have one of the child for some reason is no longer there, or you do not then later on intend to actually give this person, this child, this property because of the change in circumstances. You still can change that will. And it is important that when you're writing a will, you go to a lawyer, and once you go to a lawyer, he will guide you on how to write a will, and the witnesses, they will sign. Now, a question might ask, so where is that will kept? If you have our own personal lawyer, you can have that will deposited in that advocate's office. Or when you write a will, there can also be a situation whereby you have a person we call an executor. Now, an executor is the person who will now execute your will according to your wishes. So that person can either be one of your friends, trusted friends, people that you know who are people of good, unquestionable character. Then you can have that person as the executor. Or you could even have your advocate as the executor. The only thing about the executor is that the executor cannot be a beneficiary to your estate. Because, of course, then there will be conflict of interest. So, is a will registered? You can actually register a will, though you'll find this hardly happens. As long as a will is signed by you, two witnesses who actually saw what you wrote, wherever it is you decide to keep, that will becomes valid. The other question people don't ask is this: can we have handwritten wills? Yes, you can have. It doesn't have to be typed. You can actually write on a piece of paper. People come in as the two witnesses, and as long as it is witnessed by two persons, there is your signature, then that becomes a very valid will, and that's how it stays. A will has to be dated. This is a very important thing. A will has to be dated. So for as long as a will is not dated, then that will can be challenged. I'll come to the issues of how then, after we've written wills, then how come we still have cases. Having written a will does not in itself mean that's the end of the whole story. It means that on the point when you pass on, then you can go to court and annex that will, and you file in a petition for what we call letters of administration. It becomes very, very easy for you if you have a written will when you have a case where a will is annexed. So that kind of an application is we call an application where we have annexed a will. It makes it very, very easy because the court just looks at the will, looks at the validity of the will. If it is filed in court at the High Court. The next thing, once the High Court is satisfied that this will, your petition is, your administration application for letters of administration is perfect, then it is put in a Kenya Gazette, just in case somebody has an issue about anything about it. Then after 30 days, we'll just go back to court and you'll be given what is called letters of administration. It becomes very, very easy because everybody, the court and whoever is involved is very clear as to your intentions. So that's a very, very important, that's one of the importances of having a will, that it will also make it very easy for court now to determine. Where there is no will, then you have to involve everybody in the family. They have to put in their letters of affidavits of no objections, and it takes longer. So it is up to you to decide, do I want it to take so long for my estate to be distributed upon my death? If not, it is a very simple act of sitting down, writing your will in the presence of your advocate, bring in the witnesses who will sign, and it is kept. It saves your family a lot of problems that could happen. As I indicated, we have two types of wills in Kenya. That is written, which is actually the most important, and the oral will. Oral will, as I told you, it has a clause there that it's only valid for 3 months. Then when you're writing a will, when you're talking about properties that you want to distribute, then you have to be mindful that if it's about land, it comes under what land, the law regime for land, because different parcels of land have different laws that apply to them. If it is immovable property, it has to be property, because if today I intended to give my son X this land, then later on, it takes me 10 years, I want to sell that land. Nobody would stop you from selling that land just because you have you've included it in your will. And this is why our people would have issues, and I know of times people have had, because of our culture. Our culture has always been that modo degaya muoyo. That has always been what we were all taught to believe, and it happens. Unfortunately, the times that we are living demand that we put down what it is that we own, how we intend to be distributed, and to whom it is going to go to. So it is very important for that to happen. And I was given 10 minutes. I think I've taken you through the basics of how to write a will, what constitutes a valid will, and its validity in this country. Thank you very much.
Thank you, Kaka. I just want to add 1 or 2 points and say, for you to be able to write a will, you must own that property. If it is land, you must have a title, a share certificate. I know most of you are asking, supposing the land is inherited, it has not been shared. That is not your property so far. You can be disinherited by your father or by your mother. However, if you go to a lawyer, you will tell them that there is this property which is in the name of my father. I suspect I'll be given a share. And if I'm given a share, I would like it to go to X, Y, Z. So it is important to explain that. The other thing that I want to explain is there are many people who will ask, my children are not equal. Some will help me, some are careless, some have squandered their money or my money. What do I do? The beauty of writing a will is, like Kaka said, it is you who is in charge. You can decide that I am going to give this person a percentage and this person a lesser percentage. And you explain. For example, if you know that your children will fight, you can actually give the one you think is troublesome an extra 1%. Are we together? That way, no one in a bara moshie. The other thing is that if you think that you want to give one more than the other, the will gives you the liberty to say, I am giving John this property because he did 1, 2, 3. Tuko pamoja? So that is the beauty of estate planning. If you have any intention of, like rewarding, and I'm not saying that it is good. It is good to do it when you are alive. The other thing is, the other thing is the will also gives you the discretion to disinherit. And I'm not saying that it is right. But if you do not want to give anybody property, please make sure that you tell the lawyer the reason why you are not doing it, because when you explain that, it becomes very strong, even challenging becomes a problem. One time we wrote a will, and the MSA told us, I am not giving this person an equal share because I took him to the US, I gave him so much money, he squandered all the money, he came back empty-handed, while my other son was left here. He helped me with my businesses. He is the reason that I have been able to acquire all these properties. When we went to court, they tried to challenge it. They were not able to do so. You see, the beauty of a will. it is not the same as these others. Now, so that we move fast, we are now we shall have a session of answering the questions that you had asked. We are now talking about self-representation. As Christians, we shall ask, why do we need to represent ourselves? We are not sinners, we are not criminals. Because as we are godly people, we are law-abiding citizens. However, you might find yourself on the wrong side of the law. You might find yourself driving at a very high speed. Instead of doing 100, you are doing 110, and then you are arrested. Does that make you a criminal? No. But you have been arrested, and because you can't give a bribe, because you're a Christian, you will be taken to court. By the time you're going to Naivasha, by the time you access a lawyer and the lawyer comes to Naivasha court, what do? It is important to know how you need to respond, what you need to do. We also have other matters, like we have tribunals, the rent restriction, whereby you as a landlord, you are taken to the rent restriction tribunal because somebody has refused to pay your rent. What do? All the business premises tribunal. We have other tribunals. We also have matters to do with employment. You have been summoned by your boss or by your employer to show cause why you should not be dismissed. How do you respond? What is it that you need to do, or what is it that you do not need to do? I have had occasions where people have been served with papers, court papers, especially divorce papers, and somebody thinks that if I do not pick these papers, if I do not receive them, they have no way of showing to court that they served me. So what do? They tear them. And then, after 2 or 3 years, the person who had filed for divorce wants to get married. And you rush to court or to the church to object to that marriage. What are you served with? With a decree showing that there is no marriage. Your marriage has already been dissolved. You were living under the illusion that you still have a marriage. Number 2, you may be sued for owing money. You may be sued because of LAD. You refuse to take the summons, and then judgment. The person who has sold you goes to court, they proceed with the case, and then you find somebody coming to your house, telling you, get out, you have an eviction order. So those are some of the things that we want to discuss today. But before I call Kirago, I want to say rule number 1. If you've ever find yourself on the wrong side of the law, if you ever find yourself being served with court papers, accept the court papers, sign them, don't say anything, take them to a lawyer, ask them to explain to you. Even if you're going to represent yourself, ask them to explain to you what you need to do. Never refuse to take court papers. If you have been arrested by a police officer, usimpatie maneno mingi. Kwanza, understand why you have been arrested. If it's a traffic offense, understand why you have been arrested, so that you do not payuka and contradict yourself. Unaweza jifunga. Usitumie ya fioja mahakamani. Tuko pamoja? That is why you find hata fioja mahakamani, they are told, and whatever you say may be taken against you. So before you open your mouth to say no or yes, think about it. We are Christians. Pray for wisdom from God. Kirago will take us through self-representation in criminal and traffic matters. Kirago, over to you.
Good afternoon, everyone. Good afternoon. Am I audible? It's working, eh? Yes, I'll be taking you through criminal representation because, as you have heard, you can represent yourself. There are very many times that you'll be called upon to represent yourself, but my main focus will be on criminal representation. Unfortunately or fortunately, most people who come to the criminal courts are Christians. I do not know why. Is it that you do not give bribes, or that many Christians are sinners? For example, in the court process, there are usually three parties. And I think you know about them. I believe most of you have watched Vioja Mahakamani. The three parties, there is a magistrate or the judge. By a show of hands, how many judges are here? I don't seem to see anyone. The second party is the advocate. I know we have several advocates in the church. How many advocates are sitting in front of me? Okay. Now, the last party is usually the criminal. Where do you stand? Higher. Self-representation usually starts from the time of arrest, as our able chair has told you. Kindly, even if you are mtu wa maneno mingi, it is better to keep quiet. You will never go wrong with silence. You might end up saying things that will be used against you. So, as you have told the cardinal rule, keep quiet, if actually you do not know how to go about it. The question we might ask ourselves, why represent yourself? I believe the main or the most contentious issue is about the fees, the legal fees. Na sijui mbona mnaonanga wakili are expensive. Kaka, are you expensive? Sorry? Are you expensive? I don't know why people will want to represent themselves.
I wouldn't say I'm expensive.
Eh?
I wouldn't say I'm expensive. But again, it is not cheap to hire an advocate, perhaps.
Yeah. Let me ask you a question. Umeshikwa, you remember that time we had the COVID rules. Umeshikwa bila barakoa. Would you call your advocate to go and represent you in court for a case for not wearing a mask? Or you are arrested in a matatu because you have not put on the safety belt? And the fee, probably the fine that you'll be charged in court is around 500 shillings. And from the look of things, we have been told it's not cheap to have an advocate. Will you call your advocate to represent you for such? So I think the main issue is about costs. But how do you go about it? The provisions of the law are as provided, it's also provided for in the law that you have the right to represent yourself. And I can go into nitty-gritties and tell you even the provisions of the Constitution, but let's just be realistic and tell you an overview of what is expected. First of all, when you're arrested, you're supposed to be informed of the reason of your arrest in a language that you understand. If you are not conversant with English, insist on being told the reason in a language that you understand, even if they'll have to look for a translator. Second issue. Once you are arrested, you're taken to the police station. Unless you have committed a very serious offense, it is your right to be granted cash bail. And this is usually accorded to you by the OCS. And once I tell you about the cash bail, any money that you give either to the police or to the court system, make sure it is documented. And when I say documented, I mean there is a receipt. It's usually called a police bond or police cash bail. any money that you give that is not documented, I don't think that I will need to explain to you what it is called. Eh? Do I need to explain? And it starts with a C. That is being corrupt. Any money that you give and it's not documented, that is probably not a good route that you want to take. Insist on being informed or dealing with people who are only officers. Mtu asikuje tu hapo na plain clothes hata ajui ni nini, and you start engaging them. In fact, especially in court, there are so many brokers, even in the police station, I've seen them. Wanakuambia nipatie hii, I'll go and talk to the OCS, or give me this, I'll talk to the magistrate. No. Talk to people who are proper officers. In fact, insist on them showing you their employment badges and all that. Now, you've been given cash bail. Now, umeambiwa tarehe so and so, you're supposed to be in court. As I've told you, now there are three parties. The judge sits in front. He's being faced by the prosecutor. Na wewe umejipata on the other side. The first thing, if you've decided to represent yourself, the charges should be read to you. And when I say the charges, it is what is indicated on a charge sheet. You're supposed to be given a charge sheet. And since we will assume that you do not know how to read, it is read to you in a language that you understand. Then there are only two answers. You know, even in the Bible, we are told the answers which the Lord expects. When you pray for something, what answers do you expect? Yes? Wait? Okay. And in court, how many answers do you think once umesomeo mashtaka, how many answers can you give? It's either you accept or deny. You cannot start saying maybe or probably. No, it must be in a language that is so precise. Either yes, nimekubali, ama hapana. Let us go the first route. Umekubali. Ukikubali, there's only one thing that we are waiting. Hukumu, sindio? Sasa, that is the simpler way. Kama umekata. The next thing is you're supposed to be given all the documentary evidence that the prosecution is going to rely on. Are we together so far? You be given all the evidence or documentation that the prosecution is going to rely on. Then you're supposed to be given adequate time. Si ati upatiwe makaratasi alafu uambiwe afternoon that you are coming to hear your case. You're supposed to be given ample time to go and prepare yourself for the trial. And now I'm trying to imagine this time umesha somewa mashtaka na umepatiwa cash bail. Now you go home, you start preparing for your case. Now come the day for hearing. And preferably, I don't want to assume that we are dealing with very serious matters. Let us say probably it is just an offense of either speeding and all that. You can request the prosecution to go a different road. You do not necessarily need to go through the whole court process. There are two issues of which I will not really focus on today, but on another time, because we are given a short time, and I want, na nimesikia, most of your issues are dealing with mashamba. Na yangu siya mashamba. We'll come to deal with them. There are two options. You can go to the prosecutor and ask them to do what we call a plea bargain. That ndio umekubali, but they be lenient to you because of one or two things. Because it saves the court's time. If actually you know that you committed, why would you want to attend court for the next 1 year? Would it make sense to attend court for the whole year? Or else you can go to the prosecution and tell them, excuse me, it is like this, nimekubali. Can you be lenient? The prosecutor will enter into a plea bargain with you. Na the same can be recorded in court. They can also use diversion, that instead of this matter going through the whole process, we use other methods to try and, either if you wrong someone, to try and make sure that even the victim feels that at least justice has been served. I would also want to touch that kindly, when you decide to represent yourself, make sure that you articulate yourself properly. And if you're not eloquent enough, the law provides that you can even call an intermediary, someone who can explain to the court in a way that the court will understand best. If, for example, you're not an eloquent person and hujui kujieleza, and you know that very well, you might end up bringing more issues to yourself. It is your right to represent yourself, but in some matters you might be compelled. Okay, I will not use the word compelled, but the law provides that you should be given an advocate, especially in serious matters like in murder. The law is supposed to give you an advocate. I mean, the court should give you an advocate, but you can also decline. It is not a must. It is your right to represent yourself. And as I finish, once you're done with the court process, because as I've told you, unasomewa mashtaka, you start the hearing, you're supposed, during the hearing, you're supposed to challenge the evidence. The evidence, when you say challenge the evidence, it means that you're supposed to ask questions. If there are witnesses, ask them questions and try to discredit the information that they are giving to the court. And by discrediting, I'm not saying that you try and lie. You can just try and bring your case better so that even if it is a fine or a sentence, the court can be lenient to you. Then, let's say, for example, it has not gone your way and you're convicted. It is a right that is bestowed upon you that you can always appeal. These matters that usually, when you represent yourself, the lowest court starts at the magistrate's court. Then the next level is the High Court, the Court of Appeal, and the Supreme Court. Once probably you've started your case in the magistrate's court and it has not gone your way, it is your right to appeal to the higher court until you exhaust all the avenues that have been allocated or that are available to you. And if it goes your way and you are acquitted, you remember there's that money that you had given earlier that you are released on a cash bail. Kindly insist on the same to be reimbursed. If you do not follow it up, serikali iko na mambo mingi na unaweza kuwa umesaidia serikali. You know that apparently I hear there's a deficit in money somewhere. Higher. That is the court process. In traffic matters, I'll just touch a little bit on the traffic matters. You should not be confined in prison, or not in prison, in the police station for traffic matters, unless there are serious matters where you've caused death, or you're driving under the influence, or you're driving an insured vehicle. But these other matters, including overlapping and all that, we should not be put in custody. In fact, what you should insist on, they should give you what we call a notice to attend court. Traffic matters insists that you should not be placed on custody. Then also for traffic matters, once you've been given or you've pleaded guilty and you've been fined, the process of processing the cash, the fine that you've been given is usually done in the courtroom. Do not be engaged by someone telling you, give me money, I'll go to the cashier's or the accounts office. It is usually done in the courtroom. And in fact, by the time that you have been fined, you should be given ample time to make payments. In fact, it is usually done electronically. You can do it within yourself because at this time you still have your gadget. Maybe you might have communicated to someone and you have already been given some money. You can pay it directly. Then, if you decide to represent yourself, kindly inform members of your family or a close relative to assist you or take you to court. And especially on one day, siku ya kusomewa hukumu. I know of a case of someone who was very certain that kesi itaisha. And unfortunately, the guy did not go back home. Now the wife was concerned and was trying to tell us, can we try and find this man? And it was very difficult to tell her that, unfortunately, your gentleman, or your mzee, by now he's being processed in committee. And why would you want to go that route? On the siku ya hukumu, kindly tell someone to accompany you to court to avoid such embarrassing situations. I've seen a number of questions that have been allocated to me. I shall attend to them at the next session. Thank you very much.
Thank you, Kirago. There is a chapter in our Constitution, that is chapter 4, is called the Bill of Rights. And Article 49 provides for the rights of an arrested person. It is important to look at that chapter because that chapter will tell you what your rights are in many, many, many places. Even, for example, when you go to a government office, you have rights. So even as you talk about self-representation, remember you have rights to be served even in a government office. So look at chapter 4, Article 49, and for those who are going through family disputes, we also have children matters. If you look at Article 53 of the Constitution, it talks about the rights of a child. And that is also something else that you don't have to sit and wait for your children to be chased away from school. So either parent can go to court and ask for enforcement of their rights because you are their guardian. Kirago has talked about plea bargaining. Just want to expound it a bit. Plea bargaining is applicable especially to some offenses. For example, you may be accused of a murder. Let me use the example of a man. A man may be accused of a murder because he found his wife with another man in a compromising position. Then he took a knife and killed the man. So the reason why we said that you do not just answer without thinking about the consequences is because if you pause a bit and thought about it, you can have a defense. We are not saying that killing is okay, but sometimes you are provoked. So if you think about it without answering at once, you can actually say, this is my wife. I've been married to her for the last even 6 months. And so when I found her in a compromising situation with this man, I didn't know what to do. I took the weapon that was available and I did this. The law will look at it and it can be reduced to manslaughter, depending on what you did, the kind of force or your state of mind. You can even be jailed for a day. Another offense that you also need to think about it. We could be fighting with Elder Winnie, and then she hits me, I hit her, both of us are injured. But because mi ni mjaja, nikibie police, nishukue police, inaitwaje P3, nishukue P3, na niseme ni yeye who has injured me. Her, she's thinking it was a fight, so since we were fighting, it is not necessary for her to go and report. So she will be arrested. And then when she goes to court, she will say yes, thinking that the minute that she pleads guilty, she will have an opportunity to say, but judge, hata kama nilimgonga, tulikuwa tuna fight, na yeye akanigonga, hata mimi niliumiwa, ni vile tu sikwenda hospitali. So we see. So sometimes it's good to keep quiet and wait for your charges, like Kirago said, to be read. It doesn't mean that you are a coward. It doesn't mean that you are a criminal. Thank you. Now I call upon Jonathan. Jonathan will be taking us through self-representation in civil matters. Civil matters, when we talk about civil matters, we are talking about money matters. We are talking about insurance matters, where probably we have been injured in an accident. We are talking about, it applies even to employment matters. We've been sacked. We've not been given our dues. We have different types of courts. We have the magistrates' courts, and you file your case. The reason why sometimes it is important to seek legal advice is because our courts have been classified according to what we call jurisdiction. We have the money jurisdiction and we have the territorial. For example, if an accident happened in Thika, you can't file it in Nairobi. You'd have to file it in Thika. If, for example, you are claiming an amount of about 1 million downwards, recently we have courts that we are calling small claims. That is where you have to file your case. If your case is over 20 million, you go to the High Court. So you see why it is important, because all those things as a litigant or as just a person who does not have enough knowledge, legal knowledge, you may not know, and you can go to court and your case is just dismissed, and then we keep complaining. Sometimes our cases are dismissed, not because we have not done the right thing, but because we have failed to look at the procedure. Jonathan?
Hello, I'm Jonathan. Am I audible? Hello, nasikika. I'm Jonathan Mwangi, an advocate of the High Court. I will pass through. Hello? Okay, fair enough. I will concentrate on the small claims court. Anyone who has heard about small claims court? Anybody? Oh, okay, fair enough. Anybody who has heard about small claims court? Yeah, there exists a small claims court. It handles matters that pecuniary jurisdiction does not exceed 1 million. Those are a whole lot of cases. It was established in 2016 under the Small Claims Court Act, number 2, 2016. So most of these issues that are usually handled by the magistrate courts will find themselves in the Small Claims Court. The objectives of the Small Claims Court are to offer fairness in the judicial process, timely disposal of proceeding, using the list. Who said practice is expensive? It's not. There is a Small Claims Court where you can take your matter and they will use the least expensive mode to dispose and to adjudicate over your matter. So, you have a right under Article 50, of course, to represent yourself, right to fair hearing, lakini ni mzuri kutafuta services za wakili. And this is the reason. Most of the judges argue that when clients represent themselves, they have an issue with precision. Kirago, my colleague, has mentioned about precision. Precision in court, and especially with the judges, is a very touchy issue. Actually, judges and magistrates call this thing homemade pleadings. Am I wrong? No, I'm not. So it is, I'll advise that it's better to seek an advocate rather than to self-represent yourself. But nevertheless, since it's your right, we can tell you what to do and what not to do. The objectives of the Small Claims Court, I think I've already mentioned that, but I can peruse through again, is to offer timely disposal of proceedings before the court using the least expensive method, offer equal opportunities to all clients, equal opportunities to all potential litigants, ensure fairness of process and simplicity of procedure. The nature of claims that are adjudicated by the Small Claims Court, or the court has jurisdiction to determine, relate to a contract for sale and supply of goods and services, a contract relating to money held and received, compensation for personal injuries, set-off and counterclaim under any contract. When you go to a small claims court, actually they are situated at the magistrate courts. Most of these small claims courts, you'll find them at the magistrate court. So what are the services? What are the services that are offered by the small claims court? They will assist you in registration of the cases, assisting in person. In person are people who represent themselves, and vulnerable clients in filing of cases. They will assist in assessment of court fees, extraction of decrees and orders, drawing of warrants and notices to show cause, preparation of proceedings. Do you see the beauty of that court? You will be assisted to draft proceedings, something that advocates really charge a lot of money. Okay? They will help you in fixing of dates, and where applicable, they will help you in e-services, e-perusal, that is electronic perusal, electronic service, electronic assessment. So, small claims court, it's a new court, but I would rather encourage a lot of people to try that court. It's a good one. What are your rights under the small claims court? You have a right to be treated with dignity. You have a right for fair and timely service. You have a right of access to information and feedback on your inquiries. And then you have a right to privacy and confidentiality and safe and clean environment. My colleague Karago has mentioned a lot about self-representation. Although he was handling the criminal matters, there is a similarity with what he has said and with representing oneself under the magistrate courts and the high court. There is a lot of similarity there. As much as he was handling criminal matters, there is very little I can add on that, only to say yes, my goodness, I've been talking as Kiki. Okay, fair enough. Can you guys hear me? Have I been talking to myself or I've been communicating? How many have been hearing me? Now msidanganya tafadhali. Sawa, asante. So, how do you proceed when you represent yourself in a magistrate court? You file pleadings. Pleadings are, it depends with who you are. If you are a plaintiff, the individual bringing the matter to court, you proceed by filing a plaint. That's too deep. But first you file a pleadings, you extract summons to enter appearance, and then you comply with Order 11 of the Civil Procedure Rules. Order 11 of the Civil Procedure Rules demands that the parties, whether you are being represented by an advocate or you are representing yourself, you must exchange a list of documents, list of witnesses, the documents you intend to rely upon before the matter can be certified, ready for hearing. And after that, once the court has certified the matter as ready for hearing, you must prepare for hearing. And that is why it is very important again to seek guidance of counsel. Because many people take matters to court, and magistrates and judges have a difficulty understanding what the issues are. They have a difficulty in understanding what it is an individual wants from court, and the opposing party has a difficulty in understanding what it is expected from them. What is it are they being asked to answer? So if you must represent yourself, then you must ensure that as much as your pleadings are not elegant, they must be able to inform the opposing party of what case he has to meet, and also has to inform court of what issues the court has to determine. If you can do that, if you can express yourself that well, then you're good to go. You can be the next Omatata of this country. After that, you prepare for your hearing. You give your story, and you're done. That's all. I don't know whether there's something I've left. My seniors, all these are my seniors. So is there anything I've left? I need to touch? No, you're good. I'm good. Kirago? Okay, fair enough. I hope I've been audible enough. Anybody who needs any clarification? Any? Msiogope? No. Okay, fair enough.
Thank you, Jonathan. The Small Claims Court is a very important court in our lives. The case will take 6 months. You can take advantage. However, we are not saying that you need legal advice so that you get work. We are telling you need legal advice so that you don't have to deal with technicalities, so that you don't have to deal with small issues that may prevent you from getting judgment. If you file your case in the Small Claims Court and it is not prosecuted within 6 months, you will have to withdraw and file again. It is not expensive to file a claim there, but it might also be very tiring. Sometimes we look at the amount of money that we are going to pay in terms of legal fees, but it may save you a lot. We're always talking about cheap things, but it is not always. It might turn out to be very, very expensive. Even if you're not going to take a lawyer or to engage a lawyer to take you through the process, it may be important at the beginning that you seek services, you consult, you pay about 5,000 to 10,000, you consult, and then you get proper advice. Restrain from going to quacks. We have had occasions where even in succession matters, people get people who are telling them, I can draft documents for you. You draft documents, they are drafted longly, you present them to court, you have already paid, and the court tells you that this is the wrong document. We have had occasions where, even in land matters, you go to somebody who is not qualified. They do not even have a practicing certificate. And did you know that the information about advocates who are qualified to practice law, as of today, it is available, free of charge. Just go to the website of the Law Society, type my name, you will get information whether I am active for this year or not. If you see that I am not active, don't you dare to touch me, because you file your documents and I will come and challenge them. It doesn't matter the kind of a case you had, but it will just be thrown out. So let's be careful. There's a question that was asked, some expectation about young people, about wills. And this is what I want to say. As long as you're above 18, you have something that you can bequeath. You have something that you can give. I want to talk to women now. Some women will tell me, I have nothing. Sina shaba, sina nini, sina gari. I want us to go to our kitchen. Do we have cups? Do we have plates? Do we have sufurias? Let's go to our bedroom. Do we have perfumes and oils? Some of you are looking at me like, do I need to give out my perfume? Yes. If you have 5 daughters and you know that they will fight for that perfume, you know they can kill for that perfume. So your cups, your plates, you can give them out. So none of us can claim that they have nothing that they can actually give out. A young person, what do you have that you can give out? Subaru. You have a phone, isn't it? Probably you have money in the M-Pesa. Probably your jacket, your shoes. You can give out your books. Those are your possessions. Are we together? Those are your possessions. Don't leave them out. Put them in your will. If you look at a will that is properly done, we share out the utensils. Because we say, cups will go to so-and-so. Plates will go to so-and-so. If you want to share, to give out your bed, you give it out. Your blankets. So, there's nobody who is a modeni here. We are not poor, we are rich. Isn't it? It is not just Megoda and the big cars. Young people, they have Subarus like Kaka says. That is what is very common. So we all have something that we can actually bequeath to our beloved. And remember what we said, that we are ordinary people. By the time we leave here, we should actually think about it on how we can plan our estates for the sake of our loved ones. Allow us now to answer the questions. We have about 26 questions which we have received in advance. We are going to answer them very, very quickly. That is why we encouraged people to write questions. We didn't want to take questions on the floor because if we're going to give 10 people this mic to talk, tutatoka hapa kesho, si ndio? But the questions that you have written, they have helped us. We have shared. Kaka will start with the first set of questions. He will read the questions so that if the question addresses the point that you wanted to ask, you can refrain from asking. Most of the questions are talking about will. So what are we getting from you? Or what is the message that you are sending to us? That probably we need to organize a seminar where we need to talk about inheritance and nothing else. That is the message that you're giving us, but we are getting it. Thank you.
Good afternoon. Yeah, good afternoon once again. I have a set of questions that have been presented, and they are in sheets. So I'll read them as they are, and to the best of my ability, respond to the same. The first question that I had is, can you define the term next of kin? Most of us have experienced a situation whereby when you are a member of a circle, where you are employed, if you have Safaricom, they put in next of kin. Next of kin simply means the person who is closest to you. So that if you are a circle member, I'm sure you've seen those forms, you put in next of kin. On this one, I want to deal with the issue of men. Mostly, particularly when they are not married, they will put in their mothers, which is very fine. But I think as you get married and with time, you might want to rethink that idea of putting your mother as your next of kin. Because now you have a wife, you have a son or daughter. It is for you to determine amongst them who is the most responsible. So that once you put your mother or something like that, if again, and this was pointed out, your mother passes on, your brothers can come in and claim, my mother was named the next of kin, imali ni yetu. And you will have denied your children inheritance. So that one mostly applies in insurance payments, circle funds and the like. So that is insofar as next of kin is concerned. There was another question on what is next of kin in banking. In banking, you'll also find that when you open in an account or you have funds, you'll be asked the next of kin. So again, you will put in the person who is the closest blood relative. And as we said, there doesn't have to be your mother. For the young men, there's nothing absolutely wrong in writing your mother. But as you grow older, you then need to go to the next step. So I think I've dealt with that. There was now another question. What happens in the instance of sudden death with no will prepared? If this happens and there's no will, you will have to petition to the court. And the petition is what we call intestate. That meaning there was no will. So you go to court. If as a family you've agreed, this is how we are going to share, you can appoint two of your relatives or the elder brother or whoever it is to become the administrator. You apply to court and you're given letters of administration. And then you can determine how you want the property to be divided amongst yourself. This is purely because there was no will. And I'm sure you can now start seeing the importance of a will, because then the children have to agree. And always remember what is said. Sometimes you're the only unifying factor. At the moment you exit, they are no longer united and they are different people, so that if you're to wake up the following morning, you'll be shocked and ask yourself, really, are these my children? Because they are totally different after the death. So it is important. So where we have a will, it is called tested. Tested because you're just going to court so that the court can validate this will and everything is distributed as per your wishes. If it is a male who is applying, he's called an administrator. If it is a lady, he's called an administratrix. Those are the terms that we use, but your advocates will advise you on that. The most important thing is to know who can go to court. The wife can go to court if the husband has died, or the two children. So that can also be taken into consideration. The other question is, how is the will supposed to be written, e.g. between who and who are included or present? I think I dealt with all this when I was now showing who is supposed to be included and how it's supposed to be written. But there is no question that is not important. That is why we have to go through all the questions that were asked. Then there was another question. Can I challenge a will in court? Can you include a wife in your will? Does a written will expire? Can I challenge a will in court? The answer is yes, you can. if there is evidence that that will was written by that person and he did it under duress, because there will be people who take advantage of their parents when they are ill. And because they are ill, you are told, so people now start determining what they want. So if there is such a situation, you can challenge that will. If the person who wrote that will, there's evidence he was not mentally sound, then still you can challenge that, because you know what happened. You all know about the case of Kirima and how they went in circles, and many years there was already a will, but then that will was challenged. So the answer is yes. Can you include your wife in your will? I think I should go the other way and ask you, why not? Why not? In fact, it's actually advisable, particularly if you've lived with this lady for 10, 50, 20 years. What harm do you think will happen if you included her? There is nothing wrong in including your wife. In fact, you should. That answers that question. Does a written will expire? It has no expiry date. It can only be advanced. And this is what we call adding what we call a codicil. The other question I have is, can one contest a will given orally if the property owner dies after 3 months period lapses? This I went through about how I first of all approved and said that if you do an oral will, then you must die within 3 months. It was now meant for that. But if you are in the military and you go to war and by the time you die, it's past 3 months, but then you die much later, like after 6 months, then this is what we call privileged wills. Now that can be valid. Remember we had said it's 3 months, but circumstances might then allow for courts to acknowledge that. The other one is, does Kenyan law provide for legal action taken against any lawyer who decides to corruptly transfer properties not known by the family? There is nothing stops you from even suing such a lawyer. If there are properties that they have included or they have transferred without the knowledge of the estate, you have every other right to actually to take that advocate to court, or better still, take that advocate to the Complaints Commission at the LSK. I'll tell you this, lawyers will be more afraid to be taken to the tribunal or Complaints Commission than to court. Court huku ndio wanakaanga. So they have no problem with that. But at the Complaints Commission, if you take a lawyer there, his license can be cancelled. That is the one area they don't take chances upon. So if you have an issue with the lawyer, there is the Complaints Commission at the LSK, and the moment you go there, that lawyer is called upon and he's just shown the papers and he's told, what do you think about it? Mostly when they are taken there, I can tell you, they say, okay, I will pay. The lawyer is given time if it's money that is not accounted for, and they pay very well. So that takes care of that. Then the other question, which is I think tied to this, what happens when the lawyer leaks the details of the will to some members of the family? Now, this goes against his professional ethics. Again, nothing stops you from reporting such an advocate to the Complaints Commission, because there should be that confidentiality on the information that you're given. Remember that information, a person has given you that information in confidence. So it would actually becomes unethical for a lawyer to go start disclosing this, because you might bring fights that are not there. So it is unethical, and such a lawyer can actually be prosecuted. Can I sue this lawyer the moment I realize this? Yes, you can. Or do I cancel the will and write another will? The problem of that is, when you had that will, there is this how I wanted it to be distributed. So are you going to redistribute the same just because somebody has leaked? I think that might not be the solution. The solution still lies on making sure that that law is prosecuted, and perhaps then you now take it up upon yourself to explain to your children, hey, this is how I've decided, this is my property, mukipata zenu, mutagawana venye mnataka, but this is my property, this is how I intend to distribute. The other question is, how am I protected in all these since now the members of the family have known my intention? There is nothing wrong in all the members of your children getting to intention. In fact, sometimes it might work well. Every family is different. There are families that if you disclose there is nothing that is going to happen, actually they are going to flow on. But there could be families, because we are all different, that this cannot be revealed. So this will happen on a case-to-case basis. There are no hard and fast rules on how this one works. The other question, I think I had the most questions, but I think it's because I'm dealing with the issue of the wills, and that's actually what is more of us are more interested in. When do I write a will? Age. I think that one I dealt with it. Who is the custodian of a will? You can decide the will to be kept by your lawyer. You can also decide that the will, because the people who witnessed are your most trusted friends, you can actually give it to one of these persons, or you can even take it to the bank. They have safes where you can keep all these documents. But then you must have what is called an executor. An executor of that will is the person upon your demise who will call upon the family members and open and read the will as you had intended. That was it, about it. If one had written a will before and prospers and prepares a will, or his property increased, or if you, when the time you did your will, you had 5 properties, now you have 10 properties, you add. It's called a codicil. You can add to the existing will. There, as I told you, that document, you can even decide tomorrow to tear it down and write it afresh. It is not something that binds you forever. It is your intention as at that moment. That intention 5 years later can change. So you do not be afraid that because I've written the will, now this is it. No. It is not a death sentence. It is your intentions, and they can change. Then the other question is, what is meant by the word grant and decree in succession issues? When we apply, you go to court and apply for letters of administration. The first document you get is called a grant. Now, a grant allows you to distribute that property. Now, once you have permission to distribute that property, and you distribute that property in accordance to, either you've agreed or anything, the next document you get is what we call a confirmation of grant. So you get a confirmation of grant that this property X goes to my child Y. So you will you will only your lawyer or whoever it is, the executor, will go to the land's office and give that confirmation of grant to the land's office, so that now the title can now move from your name to your child's name. This is what we call transmission. Remember, in transmission, there is no payment of stamp duty because you are getting until the law is changed. But as of now, it's transmission. It's just moving from you, so that now your child's name or whoever you had intended appears on the title. Then there was a question of, what is a decree? A decree simply means the final order of a court. That is what it means. If you ever see something written, decree, it just means just that. Then there is there any advantage of sharing the estate of the deceased person when he dies intestate? I think this I had answered, because if you died intestate, then what that means is that either the family will agree amongst themselves how it's going to be distributed, or you leave this to a complete stranger who does not know you, does not come from your community, and all that he's using is his knowledge of law. And sometimes there is simply no justice in that, but then that's the law. How is the estate of a deceased who died intestate shared between beneficiaries? We say, this one I've answered, it's either they can come and agree that we utachukua, and that's it. Or if they don't agree, the court is the one that determines who goes with what. Then there was this question. Kama mzazi wako amewaachia land, and as a kid, children mko watatu, male and 2 ladies. These 2 ladies have sons. Is it possible to give your child a land that your parent guardian has left for you as children for their parents? Part of the reason why perhaps we acquire property is to pass them over to our children. So if I've received something from my parents and it's my inheritance, ideally, then that inheritance should pass to my son or my daughter. So this is exactly how it's supposed to be. But the moment it's given to you, it is your property, and that is how that one works. Then there is this question. Thank you very much. It says, hello, sir. Please help me on this case of Gakuyo Sacco. I joined Gakuyo as an investor club. I managed to deposit 500 Kenya shillings as it was in the agreement. But since 2016, nothing has happened. Kindly help me how I can get my money back, as since there's a lot of politics. We all know about what happened in Gakuyo and everything else, and as it is in any SACCO. Ideally, any money that you've deposited in a SACCO, you can actually go and reclaim that money. It is your money. But once in a while, you'll find situations whereby SACCOs will be taking you in SACCOs. SACCOs take you in SACCOs. And the only thing that then you need to do is you can approach an advocate who can write a demand letter to that SACCO. If they don't do anything, we have what we call the cooperative tribunal. It's usually at Kenya Insurance Plaza. Then you can file your case and the SACCO will be compelled to actually refund you that money. So there is nowhere they've gone, there is nowhere to hide, you still will get them. It might take slightly a little bit longer, but you'll eventually get it. Then there is, when is the right time to write a will? On the right time to write a will, this one had said, as long as you've attained the age of 18, I'm trying to move away. As I said, there is no time limit. The moment you attain the age of 18 and above, you can write a will. Then can I include a joint property in a will? Joint property in a will? This you can, but I think I would leave this Susan because she's more experienced on conveyancing matters. I want her to answer that perhaps in a deeper way than I would. So, back to you. Thank you. Then the last one that I have, if a will is written and deposited in a safe custody in a bank and not signed by a lawyer, will it be valid? A lawyer does not need to sign your agreement. Remember, the agreement is signed by you and the two witnesses. Those are the only signatures that are important. A lawyer could draft it for you, could just put it drawn by so-and-so, but the person whose signatures are of importance is your signature and the two witnesses. And I think with that, I have dealt with all the questions that I had. Thank you very much for listening. Thank you.
Yes, it seems I have the easiest job today. I only have a couple of questions, and I will not follow a specific order. Question number one, I need advice on a scenario. My friend had a case in court where he had hit a person with a car, and the person died. He was convicted and charged and paid necessary court charges. When he went back to pick the title deed, he had deposited, because he could not raise the cash bill up to date, he has not been able to get that title deed. My question is, does the court ask for money for him to get back the title? The answer to that is no. You are not required to give any money to get back. The title deed, once you deposited in court, it's now called, it's a bond. And the same way you gave it freely, it should be returned to you freely. And if you have an issue with that, you can write to the head of an officer called the executive officer of the court, and so that he can try and go to the records officer to try and follow up the issue. If the executive officer is not of help, you can escalate the same to the head of station magistrate. The next question is, should I allow police in my vehicle after committing a traffic offense? If he insists to enter, what do I do? Essentially, your car is private property. No one should trespass inside that vehicle unless you willingly agree to them. But on this issue, let me just be honest with you. Would you prefer that they don't enter into the vehicle, they tell you to get a friend to come and take the vehicle, and you are carried behind in the Land Cruiser? Which one would you prefer? Would you prefer to be carried in a Land Cruiser or give this police officer a lift? I think that is up to you. After a vehicle is found not to have valid insurance, is it supposed to be towed as the police instead insist on doing? No. By virtue of you not having an insurance, it does not mean that the vehicle is mechanically damaged and it cannot be driven to the police station. I can give you another scenario. By virtue of you being arrested for not carrying your driving license, does not mean that you do not know how to drive. In fact, if you're taken to court, you can be given time to come and prove that you actually had forgotten it probably at home, but that will just reduce one offense to the other of not carrying or not producing a driving license when required. Can someone be jailed because of a debt one is not able to pay, either to bank or to an individual? Owing someone money is not a criminal offense, but yes, you can be jailed. You can be jailed after going through the civil process in court, and judgment has been entered, and it has been declared that you should pay so and so this amount of money, and it can be proved that actually you have this money, and it is just a matter of you refusing. Otherwise, what I can tell you for a fact, it is not illegal to being broke. It is your right to be broke. Sawa sawa. Haya. Explain that it is illegal for any man or woman to have intimate relationship with their partners when they are not themselves mentally. In Kenya, unfortunately, we have not advanced sana kisheria, where we are not yet to develop what we call a marital rape laws. But now in this question you said that this is your partner and they are not mentally themselves. Consent cannot be given by a mentally challenged person. It's the same way where a minor cannot give you consent, and it's the same way a drunk person cannot give you consent. But unfortunately in this scenario, this is your partner. I don't know what you mean by partner. If you're married to this person, unfortunately now you're bound by another issue, that what people commonly say that I want my conjugal rights. But you see, at the end of it all, this is your partner. And we all know that they are mentally not themselves. So it is more of a moral issue than a legal issue. Are we together? Have I communicated? It is more of a moral issue, not a legal issue. The same way if probably you're dating a mentally challenged person and we found you and in the act, how will you convince us that mwenda wazimu alikubali mkue pamoja? You get. But if this person you got married to, and unfortunately due to some illness or something, they become mentally not themselves, it is up to you and your conscience. That's all I can say. Does a P3 have a time frame? No. A P3 does not have a time frame. You can take a P3 even after 20 years, kama uligongwa na ukafura, and you can prove that bado umefura after 20 years, you can still go. There is no time frame. Same way as criminal matters, they do not have a time frame. That's why you'll hear mtu all of a sudden wamekosana juzi, lakini anakumbuka alipigwa 2015, anaenda anasema nilipigwa na hata leo bado nasikianga hiyo kichwa iko sawa, just to get vengeance. Haya. If I have been arrested and I would like to represent myself, would I be allowed to gather evidence, facts to support my case, or will I be allowed to get help from outside? If you want to represent yourself, it is your right to get as much as evidence. If the same evidence that you want to rely on is within the government offices, government documentations are usually public documents, and unfortunately, the government will not assist you to get evidence so that you can make your case in court. So it is up to you, but it is your right to be given any documentation that you will want to rely on. Can inmates be allowed to write a will if they own some properties? I don't think, is that mine? Okay, I'll try. Yes, an inmate is still a human being. He has all the rights. he enjoys that are given by the law, apart from one. Can someone please just try and assist me? Which do you think that right that an inmate doesn't enjoy? It's just freedom. Just ni kwa sababu tu yuko enclosed somewhere. But even you can see the government is still under the obligation to give them clothing, give them food, take them to hospital, because they are still humans. Hi, I've been having a court case concerning land. It has taken 10 years and it has not been heard. Every time the lawyer gives excuses to adjourn the case, what am I supposed to do so that the case can be heard without further delay? That's a very good question. You see the benefits of having a lawyer. Now you can also get a lawyer to try and speed up the process. But essentially, if you want the case to be heard expeditiously, as it is your right, according to Article 50 of the Constitution, all matters should be heard in an expeditious matter. And as you know how we usually say, justice denied. Justice delay is justice denied. You can try and complain. There are offices where you can complain, including the Office of the Ombudsman, to try and get, if at all it's on the part of the judiciary. If it's the part of the magistrate, you can raise that issue in court and tell the magistrate, unfortunately, that this matter has taken too long and there is really need for the matter to come to a conclusion. I understood the issue, probably if it's a criminal matter, you can, and it involves land, because some matters are for land are also criminal, you can write to the prosecution and try and get feedback. And if you don't get feedback there, we still also have a complaints office in our office. You can feel free to raise the same with our same. Thank you very much.
Jonathan?
I have only two questions. One of them deals with an individual who had a judgment delivered in their favor, but the judgment debtor did not have any property to be attached. So this individual is at loss as of how he's going to recover their money. I'll advise the individual to have the judgment debtor or the individual who owns the money committed to a civil jail. If truly he has wealth or he has money and is hiding it within his family, he will pay. If he does not have, he will explain to court that he does not have money, and there's really nothing you can do about that. So just have him committed to civil jail so that he can harakishe kulipa kama pesa iko. The other one concerned an individual who had an oral agreement, and the person they gave money has refused to pay, paying in installments, and has refused to honor the end of the bargain. To be practical, try the matter with the chiefs. The chiefs do handle a lot of these issues. If it fails, courts also do recognize oral agreements. It's advisable to have a written agreement, but it's not. Sometimes you're allowed to have an oral agreement. It's allowed in court. So you can try and enforce it in court. But first try to consult the chief. Wanafanyanga kazi mingi sana, wanaweza kusaidia. I don't have any other question. Those are the only ones I was to handle. Yes.
Thank you, Jonathan. I have the last set of questions. I'll try to be fast. We are finishing. The first question is scenario 1. If a husband dies and leaves property to his family, but there are challenging circumstances, for example, the children are still young, family members are not cooperative, can the wife change the will? Does she have enough power? The answer is no. Once a person writes a will, he's the only person who can change that will before he dies. Once he dies, you can't alter that will because the law will catch up with you. It will be forgery and what we call interfering and meddling with the property of a deceased. What you are supposed to do when you're writing a will, once again, be open to your lawyer. Tell them, my children are below 18. Where you have any child who is below 18, you are supposed to have 2 executors or 2 administrators to safeguard the interest of those who are below 18. Is there a way to know forged papers, their authenticity? Where can wills, titles, and okay. Yes, there is. If you have any doubt that that will was not written by the deceased person, what you need to do is to take the previous signatures of that person. You can take them to the CID headquarters, or you can get what we call a document examiner to examine those documents and the signatures to know that whether they were actually written by the deceased. Another way to know whether these documents are forged, remember Kaka said that a will must be dated. Look at the date. If that person was ill for a certain period of time, you can actually tell. So it is also, it is easy. There was a question about where can wills, titles, and personal documents be stored. Kaka said it's in the bank or with your lawyer, or you can give it to one of your confidants. Scenario 2, when or what time should someone write a will? Kaka said any time you are ready as long as you meet the conditions. Does it only have to be time when the family has struggles? No. I think that was answered. Question number 2, which child should inherit the family house? I think this actually depends with you as a parent, because you might think that your last born is the one who is going to inherit as per what we believe in our Kikuyu customs. But that child may be better, may be well off than all the other children. Do you really want to give them that house when the firstborn doesn't have a house? Or do you want to give your lastborn a house when he actually lives in Nairobi and your son who lives in Geshagi doesn't have a house? Does it make sense? So that is why we are saying, even as you write the will, think about it, the consequences. If my husband has a joint land with his brother, how should I inherit it in case of death? Remember when I said about joint, if it is joint and it is indicated as joint, when your husband dies, his brother becomes automatically the owner. However, there are people who are very good. They will say, we are going to share. So even as you think about joint proprietorship, joint ownership, if you're not husband and wife, if it is a brother, sister, and sister, have what we call common joint tenancy in common, where you indicate in the title, I have 50 shares, I have 50 shares, so that when you die, your 50 shares goes to your people. But joint automatically goes to the surviving spouse. If a parent dies and don't leave a will, I'm reading as it is, what happens? The Kaka said it is subjected now to like an intestate, where the court will decide who will take what unless you decide you agree. The brothers have taken over everything and don't want to share with the sisters. What if the sisters cannot afford lawyers? We were made to sign documents without realizing we were handing over our rights. One, it happens. But we have institutions that give free legal services. One of them is called Kituo cha Sheria, and there is also FIDA that will give you advice and they will help you in representation. So if you don't have money, or if you're not financially, you're not able, please seek legal advice. You can actually go even to the Law Society and they will refer you to those organizations. You can go to the Family Division at the High Court if you're in Nairobi, or even now, the lower court, we have started a family division, and they will advise you which organizations that you can go to. We also have in the High Court, recently they have started what we call pro bono scheme of lawyers, especially in the family division, where you can get lawyers who can represent you. They will be paid by the government some minimal amount. But you have to go through an interview to determine that you can't afford. So all is not lost. Number 2, they have raised the issue of documents. Don't sign documents before you know what you're signing. Don't sign blank documents, because you are going to sign your birthright. Like who? We have a case at the High Court where after my dad's death came up, a family and said he had another wife. So they want the lad to be divided by 2. He passed away in 2010. By the time they came up in 2013, all properties have been changed to mom's name in 2015. This is a bit complicated. When a family comes up after somebody has died, it is upon them to convince the court that they were indeed a family of the deceased. So they will have to go through the the hearing. If it is a woman claiming to be a wife, she will have to prove that indeed she was a wife. If it's customary, were the rights done? If it's about the children, we can do a DNA test with the children who are surviving. Some people will even go to an extent of saying, we want the body exhumed so that we can do a DNA. So that can be done by DNA. If the property has already been transferred to your mom's name, the only thing they can do is to go to the High Court, apply for what we call a revocation of grant and the certificate of grant, so that now the court can listen to them, but again, they have to prove that that is a wife and the children. So it's not a simple thing. It is something that will take a bit of time. There's something else, though, explanation of Article 1 on exercising the sovereign power directly. This means Article 1 of our Constitution, that's the one talks about the sovereign power belongs to the people of Kenya. It means that we are not subject to any external control. We cannot be influenced by any other government. For example, as much as we talk about the United States being a very influential power, there is no way they can come and tell us, we want you to govern yourselves like that. That is basically what it means. The power belongs to us. The power belongs to the people of Kenya. And that article has said how we can exercise our power through the leaders we have elected. How to present a petition in a court of law. We have many different types of petition. We have a petition in a divorce case. We have a petition in an election matter. We have a petition in a constitutional matter where you are challenging any arm of the government. Then we have a statement of claim in a small court, and then we have a plaint in a lower court and in a high court. All these, you can do them differently. It is something that I may not be able to explain here, but what is important is you explain who you are, you explain who the person you are suing is, and then you say the reason why you are suing them. If it's money, you state, and then you tell the court what you want. Do not give your evidence, because that will be accompanied either by what we call an affidavit, stating the facts of why you're taking that person to court, or if it is what we call a plaint, a statement to say that I did this and this and this, that is why I'm coming to court. But whoever wrote this question, if you want to be expounded further, please talk to us. We've seen cases where a person is presumed to have been issued with court summons, but in reality it has not, and the case is judged against him. The law is not quiet about that. If somebody comes and says that they served you with summons to enter appearance or summons from court, and there's already judgment, the law provides you with an opportunity to go to court and ask for that judgment to be set aside. In simple terms, I'm simply saying, you're telling the court, I was not served, and therefore I want you to remove this judgment because I want to continue with the case, I want to defend myself. And then you must give reasons. For example, there's somebody, court documents are not just served by anybody. As a person who has gone to court, you can't take the documents and serve them yourself. It is either an advocate who is qualified and has a practicing certificate who can serve documents, or people we call process servers. They have been given that authority by the court. They have their licenses and they renew their licenses every year. So the first thing that you need to check, again, you can check from the website of the law of the High Court whether that person has a current license to serve. If not, then you can go to court on that basis that he's not qualified. If they are saying they served you, for example, if you live in Kariobangi and they are saying that you live in Buruburu, you can challenge them that. So you have that option. When you are represented by an advocate in presenting your case, you feel there is a point that was not presented, can you start and add anything? No. You're not allowed to say anything in court because you have a lawyer. However, the reason why we go with our clients to court, if, for example, I'm cross-examining the other party, my client has a right to pass a paper like this and tell me to ask this question. If I'm making my submissions and my client feels that I have not captured everything, you pass a paper to me and tell me that I have omitted this point. If a lady has no husband, does she have any right to be given property? It's written by his father, but by her father. Bona, last bonds, hawakuwa, hawadikwangi kwa next of kin. This one is very personal. You know, sometimes, remember what we said when we were starting. When sometimes we update our documents, last bonds hawajakuja, we forget. Just like hatujaolewa, hatujaoa, we forget to update that. Hakuna mtu anashukia last bonds, ama last born. Hakuna mtu anapendwa na anashughulikiwa kama last born. So unless it was an omission, that is as far as, I don't know, that is very personal. So about a lady who has no husband, I read the book of Job, 42 verse 15. Job gave his daughters, property, just like his sons. And I said, we are ordinary, we are Christians. What does that tell us? God does not discriminate against us, even the children. Section 29 of the Law of Succession Act, it defines a dependent and a beneficiary as a child of the deceased. It does not define a child as a son and a daughter. Who is a child? Is either a daughter or a son, isn't it? So the law does not discriminate. Our Constitution, 2010, it talks about a child of a deceased. It does not discriminate. And therefore, the law does not even say that if you are married, you can't, if a daughter is married, cannot get property. No, the law does not qualify it that way. All your children are equal. and I'll tell you the reason why. Allow me to take 1 minute. The law of succession does not give a spouse any right to inherit their property, their spouse's property. Am I right, Kaka? What they get is a life interest. If my husband died today, his property, I'm only entitled to a life interest. I will live there. I will earn my money from there. I will be supported until the time I die. When I die, that property goes to our children or whoever it will go to. It is the same case or the same scenario with a man. And therefore, when we are talking about a woman who is married not inheriting because they will inherit twice, we are making a mistake. However, I know there are amendments that have been taken to Parliament. It's only that Parliament is dragging itself to ensure that a spouse inherits from the other spouse without necessarily being given a life interest. And that is why we talked about estate planning. If you're doing estate planning, you give your property. Kaka said, why shouldn't you give your wife? Why shouldn't you give it to your husband? Does a daughter-in-law have any inheritance rights on her father-in-law's property when they die? Yes, they do. They do not inherit from their father-in-law. They inherit their husband's portion. Tuko pamoja? They inherit their husband's portion because their husband was entitled to inherit, especially if they have children. And if he has a family, they are entitled to inherit just like the ones who are surviving. Can someone give an oral will on their deathbed and immediately die after uttering the will? You see, even if you're talking about dying within 3 months, your state of mind, remember what Kaka said. If you are very sick, that will be challenged. So why wait until you are almost dying and then you give an oral will? An oral will be challenged because of your mental capacity, your health capacity, and such things. An unsigned will, is an unsigned written will valid? No, it is not. Because who is the witness to come and say that they witnessed it being signed? Must all the siblings agree for a grant to be given by a court? Yes and no. Where you agree, it is okay. Where you don't agree, there's something, the law has an answer to every situation. The law provides that you can summon the ones who are not agreeing, take them to court, let them come to court and tell the court why they are not agreeing, and then the court will take up the matter. Fortunately, these days, we have mediation, so it may be referred to mediation. In case of joint ownership, how do you go about writing a will if you are not in an agreement with your partner? The joint ownership, unless you sit down and say that we want to leave this property, me and my husband, to so and so, you cannot do it alone because that property does not belong to you. It belongs to both of you. So you can't do that. Why is it that a wife cannot be an executor when the children are indeed beneficiaries? Kaka said the wife can be an executor. What he said, and that is what is a position, the wife, the beneficiaries, or any person who is benefiting from the will cannot be a signatory or cannot be a witness. Can I include a joint property in a will? I have said no. How can one go about a divorce when you don't have a marriage certificate, when you got married in the traditional way? Can someone, okay. If you got married under the customary law or it is come with stay, the law provides for a procedure. You will file what we call a plaint in court and ask for the court either to declare there was a marriage. Once the court declares there was a marriage between the two of you, the court can go ahead and dissolve it. So, and what people don't understand is when you're married under customary law, people say, nikitoka nimetoka. And that is why we are finding many cases after people have died. Because that person is still your husband, is still your wife. So if you divorce, you need to do it the right way. Can someone write a will if even your husband has written wills? In this case, if I have properties which the husband does not know, gaifafa. Tunasema tu ni wanaume. Why would you want to hide a property from your husband? Let me tell you something. We normally say we do not know the hour, isn't it? If you have 5 properties and your husband does not know where these properties are, what are they for? Are they of any use? Have you heard of properties in Nairobi where properties, people have died and nobody knows where the owners are? I know about 2 houses in Buruburu Phase 1. The tenant who lives there, they don't even know where to pay rent because mwenyewe alikuwa anakujia rent. So, you are toiling for who? Your people will not even benefit. So finally, either the person who is there will benefit, they are going to forge documents. They are going to claim adverse possession because they have been there for over 12 years. If it is a bank account and your people do not know that you have a bank account, what happens? Unclaimed assets. Who benefits from unclaimed assets? The state. Not even the state, by the way, does not benefit. It is the people who work there. So why are you toiling? Why do you wake up in the morning? Why are you hiding properties from your spouse? Why are you even hiding your properties from your children? Why are you toiling? Please, for heaven's sake, I'll keep on repeating this. We are an orderly generation. We are an orderly people. We serve a God of order. We belong to a Mutaratara church. Let no Christian die without a will. Let us not wash our dirty linen in public. Can you imagine an elder tukienda kotini? Sorry, elder, to use this. Tukienda kotini, alafu tunaanza, elder Wajere, let me use you. Tunaanza kusema, elder Wajere, Wageshi, who, they are the ones fighting their mother. And the way we respected elder Wajere. Can you imagine, elder Kang'ethe? You know. Alafu watu waanze kusema, washana na watu wa PCA, washana na maelders wa PCA, wanakuanga hivyo. Let us be orderly people. There's another one. Is there a limit in the number of time you can change your will? No, but every time you do, remember to tell whoever is writing your will that you are revoking and cancelling the previous one. And make sure you tell it. Isn't it, Kaka? So that nobody will get it. Because you can have 4 wills in a court of law. You know. And then, if you're the one who is going to write it, please write it properly. Make sure you burn the earlier one. In land, some areas are fertile. In the will, some might have acquired fertile land. In case one appeals, how does the court solve this? You see, I said that when you're giving out property in a will, explain the reason why you're doing so. Explain. Because the fact that you have given me an infertile parcel of land and you have given Elder Winnie a fertile parcel of land, that will not invalidate a will unless I'm wrong. It will not invalidate a will. Again, we must understand, and let's get it very clearly. It is not a right for your parent to give you their properties. You have no responsibility as a parent to give your children your properties. You can eat your... We normally joke when we used to go to court. We used to say, we eat 2/3, we leave people fighting for 1/3. Don't allow yourself to suffer so that people can fight. Isn't it? Because if you look at most people who fight, they are those people who come from families where their parents walikuwa wame konyitia moshivi, ata lunch, ata nyama, ata nyinyi hawakuli. So we are all waiting for them to die. We are fighting for them. I was being told yesterday that there's a family that went and they beat their father, asking him, Ogakwale, muthĩ ũyũ nĩgetha tũgayane indo. So he had to share out his property. He's still alive. 5 years down the line, none of his sons is alive, and they have sold the properties they were given. And those are actually true stories. If my father gave that brother, he gave that brother with, okay. Allow me. A boy was electrocuted as he was playing outside, is it a balcony? And eventually his heart was amputated. Who can I sue? Landlord or KPLC? You can sue both of them, because probably the wires, the way they were wired, there was some negligence. And KPLC, because they're the ones who were supposed to inspect, they were supposed to have known that there was some negligence. You sue both of them. However, I do not know when this boy was electrocuted. If 3 years have passed, you can't sue it. Civil cases of negligence, we are supposed to sue within 3 years from the time that the accident happened. If it's something like a contract of money, that is 6 years. So if 3 years have not lapsed, you can sue both. If you led a friendly loan to a person or loan an item and refuses to pay, can you sue him or her? Yes. But remember, when you are lending money, please make sure that you reduce it into writing, because you will need evidence. If, for example, ulimpatia tu pesa, 10,000, do you have any evidence to show that you gave money? He will go and atakuruka. You can take them to court, yes, but you must have evidence. It has happened. There are people who have sold property to other people, and because it was a friendly agreement or a gentleman's agreement, wanawaruka. Let's see whether we are able to understand. Okay, let me read the other one. Or if my father, he gave that brother with mouth, not in a written will. Mouth is oro, yes. Not in a written will, but written imeandikwa RETEN, will. What can I do? Again, remember we said, if they gave them in, it is an oral will, did they die within that period? We talked about gift inter vivos. The old men of Tene, what they used to do, they actually used to say, this is where I have given you. And they actualize it. They put beacons and such things. So you cannot just say that I have given you. You know, it is like something we call, you can give when you're in hospital, like you say, my car, KDA, I've given it to Elder Kangeve because I'm thinking that I'm dying. But then I recover. I'll take my car because I was giving him thinking or contemplating that I'm going to die. So if I die, if I recover, I come and take my car. He has not benefited. What about my father decide not to give lady plot, title, and I have been born in that family, in that big family. I have 3 children by now. I'm alone. What can I do, because that title for the family not yet decided? What do you do? You are entitled. If your father has died, you are entitled. You can actually take out letters of administration. You can serve your other siblings with papers to come to court and show cause why you should not be appointed as an administrator. However, if your father decides to give out his parcel of land when you are still alive, and he decides to transfer the titles to his sons, there's nothing much you can do, because you can only take him to the chief and say that he has refused to share out that property. But remember, nobody can force you to give property to anyone. And I think there is a case that was, there's a judgment that was delivered the other day saying that it is not automatic that as a child you're entitled to your father's property. Those are the questions that we had been given. And to wrap it all, it has been a wonderful session. We, as your presenters, we have enjoyed interacting with you. Today we feel that we have actually done something. We have given it to you for free because that is part of our calling as members of JPLC, and we feel fulfilled. I keep on saying that Colossians 3:23 tells us, whatever we do it like we're doing it for the Lord, not for human beings. Because once we do it for the Lord, we will never get tired. We will never complain. These people are not complaining that you are not going to give them money. They are not getting any money. Elder Sarah can confirm that. They have done it for free. We shall do it. All we need from you, if you think there's a topic that you'd like us to discuss, whether it is legal or any other topic, JPLC has that mandate. We are a standing committee created by the PP. We are ready to source for resources. Saturday, give us your Form 4 leavers so that we can talk to them, explain to them what they need to do. If they need to revise the courses that they had selected, our mentors are ready. We shall be here by 9, and we are going to release them by 11 or 12. And they will never be the same again, so that we do not have students who are going to university or colleges, and then in third year, they're coming to tell you, this is not the course that I wanted. Or after they complete their degree, they bring the certificate to you because it has happened. They tell you, Mom, Dad, this is your degree. I want to do a different course. So because we have that, we are, as Kariobangi South, we are blessed. We have a lot of talents in this church. We need to tap them. We need to keep these people busy so that we can also sustain and maintain them here. One of the reasons why people decide to go is because they are not committed. We can only commit them if we trust them with, like our children, our Form 4 leavers. Release them, they will be in safe hands. We are coming to the end. I am going to invite 2 people to give an overview, some comments, and I'm the one who is going to choose. Or you want to raise your hands? Can I choose? Can I pick one? I'll pick Elder Kang'ethe because he has been here from the beginning. Then jitayarishe nitakuita wewe mwingine.
Thank you, Wakili Kaka, Wakili Kirago, na Mwangi. Thank you so much. And also the JPRC team. We all believe that, we all agree that we have learned quite a lot. That is what we call it what? Pro bono. Yes. There's a question that I raised and it was answered so well. So, Wakili, thank you so much for educating us. Some of us go to jail for very minor things. Unaenda na gari yako inavurutwa na hiyo gari ilikuwa inajiendesha. So, Wakili Kirago, thank you so much. Mambo ya kitu kidogo, I think that is the area where we are, most of us are going wrong. You are speeding, going, like me going to my home in Katanga. I'm flagged. Policemen are so cunning. They quote Matthew 5:25. Sijui kama hiyo mnaijua. Matthew 5:25. You settle your matters with the arrestor before they take you to court. So thank you so much for that enlightenment. We are happy. We are now educated. And may God bless you so much. Asanteni. Situpigie hao makofi.
For the interest of time, I'll call Esther Wagema to give a vote of thanks. Then Elder Mary, I'm calling the members of JPLC. We'll close with a word of prayer.
Hamjambo. First and foremost, I want to take this opportunity to thank for giving me the opportunity to give the vote of thanks. I'm not in office currently, so it's an honor. Tumefurahia. Tumesoma. Let me tell you, sometimes, as long as we are living in this world, we might take legal matters for granted. But one day, it can catch up with you. Na hiyo kidogo tu umesoma hapa itakusaidia kukuokoa mahali. So value it, treasure it. This team these are all our members except for Jonathan, and Jonathan is still our member by extension. Wale mnajua Mama Aida, this is a son to the sister of Mama Aida, a member of PCEA Kayole Church. So ni wetu bado tunaweza tukamfikia, si ndio? For Kirago, if with his permission, I would say he's a prosecutor. Ukijikuta katika mashaka kotini, he is currently a prosecutor in our courts. He can be of assistance. But lakini ujue, ukue hakika uko msafi. Ni kweli. Aya, my small mandate is to give a vote of thanks. And I want to first of all take this opportunity to give thanks to God for enabling us to be here today, because purposing is for man, but kutimiza ni kwa nani? Ni kwa Mungu. So first vote of thanks goes to God for that. Number two, I want to thank the church, the CAC session, and the reverend, because tungeomba nafasi na tunyimwe, si ndio? Kwa hivyo, the session, kindly return our thanks to the office. We really do appreciate for being recognized for this. Number three, I want to take this opportunity to say thank you, our facilitators, for your pro bono services to us today. May God bless you, may He add unto you, and may He give you clients that in the times of your need, you will not lack. Our patron, my heart for you. He has been very supportive. He has stood with the office of JPRC, and he has facilitated. I think this time round, you can see we have really done a lot. Sometimes we may want to do it, but if you do not have a supportive captain, meli haiwezi kaenda mahali, si ndio? Kwa hivyo, our patron, we really thank you. The office of the JPRC, headed by Susan, may God bless you and keep you. We really appreciate what you're doing for the people. And eventually, us all. Sisi zote, sisi tungekuwa na kazi nyingi tungefanya huko nje. Lakini tuliona ni vizuri tuje tusome in accordance to the word of God. Let us not be ignorant. Hosea inasema, my people perish for lack of knowledge. You have chosen knowledge rather than ignorance. May God bless you. Situjipigia makofi wote kwa kubali kukuja. Kwa hivyo tunashukuru, tunasema ni asante. Wakati mwingine tukiwaita, tafadhali kujeni. We really want, and if you have anything, even if we have not called out for information from you to teach us, for facility, nitasemaje, kama hatujaitisha topics, If you feel there is something you want to learn, like Mrs. Mainge just whispered to me, tuleteeni sasa ma magistrates, atatueleza ni wakufanya nini. Lakini ukisikia unataka kusomeshwa kitu fulani, tuambie tu na tutafanya vile tunavyopaswa kufanya. We are here to serve the Lord together with you, so that we shall be knowledgeable. Asanteni sana, Mungu awabariki na watende mema mnapoelekea makwenu. Asante, God bless you. Mary.
Bwana asifiwe. I want to thank the JPLC team for the good work that you're doing. We are indeed thankful. Your work is commendable. Isn't it? Situwapige makofi. Tusimame for a word of prayer. Our Father and our God, we are indeed thankful for your faithfulness and even for your lordship over our lives. You have been gracious to us. You brought us to your sanctuary this morning. You fed us spiritually by your word, and we are thankful. Again, Lord, you have gathered us here for this wonderful session that had been organized by the JPRC team. We have learned a lot. We have been educated. We are wiser and sharper, and we give you all the glory and honor. We want to thank you, the JPRC team, the office, the patron. We pray, Father, that you'll continue to strengthen them, to give them wisdom, so that they'll be able, Lord, even to organize such kind of forums where your people are going to learn a lot, because knowledge is power. We do not take it for granted, but that at such a time we are here. We want to thank you for our presenters. Thank you for Kaka. Thank you for Kirago. Thank you for Jonathan, who have offered their time, their talents, their expertise freely. Lord, it is only you who can be able to repay them. And so, Lord, we ask you that you will meet with them at their very points of needs. We pray, Father, that you will extend their territories. And Lord, every time, any other time that they are called to come, may they come willingly like they have come today. We continue to pray for their works. Wherever they are, they work, the ones who have their farms, the ones who are working, that, Lord, you will give them favor before their clients, favor before their employees, for the glory and honor of your name. Thank you, Father, for the leadership of our church, for even allowing this team to have this forum. We pray, Father, that you will continue to shepherd this church, that, Lord, you'll continue to increase them in wisdom and in knowledge, that even the congregants, Lord, they will continue to feel that they are fed in the light way. And for us people who came, who heeded to the call of JPLC, we thank you because we obeyed. And so, Father, whatever we have learned, it is our prayer that you will help us to implement, and more so even lighting the wheel that we've been taught. Because, Lord, you've called us to be orderly people, that when we depart, we will live an orderly way of inheritance. Father, continue to speak into us. Continue even helping us to share that wonderful knowledge to the other people, so that we too can be blessings to others. We thank you, we bless your name. Thank you for the week that is starting tomorrow. We ask you that your presence will abide with us. Father, go before us. Go ahead of us in our places of work. And even in our homes, Lord, go before us. That even when we go back to our homes, Lord, we shall say thank you. We thank you, we bless your name. This is our prayer of faith in Jesus' name. Amen. Now the grace of our Lord Jesus Christ and the love of God and the fellowship of the Holy Spirit be with us now and forevermore. Amen and amen. God bless you.